over the last 13 years, I have spent the vast majority of my professional life dealing with software license transactions and disputes involving major publishers, but with a heavy emphasis on Microsoft. And so today we're going to dive in at a very high level to some of the issues that we're experiencing in the transactions that we're working on. Turning to the agenda, Microsoft, like many software publishers, is amidst a revolution in terms of switching its approach and business model from what has historically been an on-premises plus maintenance model to a cloud-based model. We'll talk about some of those differences, including Microsoft's new SPE offering, which is an interesting twist on user-based models and works very nicely with its cloud model. We'll talk about agreement types and the basic agreement soup that Microsoft presents to its customers, how those agreements work together, and what you need to be focusing on in reviewing each one of those agreements. And then we'll spend the bulk of our time on the legal topics, looking at defining requirements and building a term sheet, two things that I always recommend to my clients as ways to streamline the negotiations with Microsoft and avoid inefficiencies in those discussions. We'll talk through that, as well as many of the key issues that we're recommending to our clients to be negotiated in connection with Microsoft, either renewals or new transactions involving enterprise customers. As I mentioned, the old world of software licensing was centered around perpetual licenses where the vendor would provide the bits and bytes on CDs or downloads and would be paid for some maintenance. In the case of Microsoft, the optional software assurance approach. Today, Microsoft, like many, are moving to subscription and cloud-based models, and it has really changed the legal landscape in terms of how contracts are being put together and how they're being negotiated. Even under 10, 12 years ago, when I was representing enterprise customers in perpetual license deals, I was always looking at ways to make it easier to count and manage and to emulate user-based approaches to things like counting devices. Because for the hundreds of clients that I've represented, from two-person lumber yards to the largest banks in the world, they all have one thing in common. It's very difficult to count devices, and it's much easier to count people. But when you switch from perpetual to subscription, you change the focus. And things that used to be boilerplate in perpetual software license agreements now can be the most important provisions. The one that comes to mind, and we'll get to later, is limitations of liability and other privacy and security issues. Privacy and security, who pays if data goes missing, regulatory obligations. These are the drivers in software negotiation today, whereas 5, 10 years ago, these were not even issues in the discussion. Business continuity is another one. In an on-prem world, you don't really worry about business continuity. You're in control of the data center. When you go to cloud, the vendor's data center and its availability dictates your ability to do business, and if it goes down, you go down. It's a very scary position to be in. One of the biggest things that I think has driven the rise of cloud and subscription-based models to the extent that it has is the corporate America's preference for OpEx for IT as opposed to CapEx for IT. There has been a fundamental shift in the way businesses look at financing and funding IT operations, and the preference by and large in the market has been for treating IT expenses as operating expenses to be used as needed, that can scale up and down based on business requirements, as opposed to a capital project which carries risks of fluctuation and other issues regarding accounting treatment. The other aspect of a switch from primarily on-prem to cloud-based deployments is it enables the transition, something again that I've supported for many years, from a device-oriented approach to counting to a user-based approach to counting. Years ago, I used to spend so much time negotiating the profile definitions for my clients because I wanted to get away from harmful provisions in enterprise deals that hindered a client, for example, that had multiple users per device. A user-based model for that client would be unfair. For example, a hospital system that had multiple nurses on a floor using a device, a call center that had shifts with multiple users per device, did not want to be in an enterprise agreement that defined the pricing trigger on a user basis because they had so many more users than devices. On the flip side, if the client is a bank or a large law firm, they may have multiple devices per user. Take me, for example. I've got a desktop on my desk. I've got a laptop in my backpack. I've got an iPad by my bed. I've got an iPhone in my pocket. And so why would that customer want to pay on a device basis when they've got multiple users per device? And so we were constantly negotiating for these hybrid models where some things would be device-based and some things would be user-based. And I still have some clients that are doing that, and it can be much more targeted approach to spend, and it's something that I think the cloud is uniquely positioned to deliver. I think Microsoft is, as all publishers, heavily focused on cloud-based offerings. It is a function, I think, of capital markets, particularly Wall Street, and its desire or perception that cloud-based revenue is the most important metric, and the behavior of the publishers is responding. I mean, the publishers are responding to this urgent need in the marketplace to drive cloud-based revenue. And so if you're negotiating with Microsoft or any of the major publishers and you want to know what your leverage is from a business perspective, cloud-based spending is your leverage. Every major publisher, Microsoft included, is very focused on cloud. And if you've got a deal that expands your use of Azure, SharePoint in the cloud, 365 in the cloud, then you are going to be speaking a language that is going to be very well received from a business perspective in Microsoft, and it's going to be something that it very much is interested in hearing. The newest offering from Microsoft, released in mid-2016, is a broad-based bundle in a device and user-centric subscription licensing model that has some interesting components to it. And if you're negotiating with Microsoft and they haven't presented you the SPE proposal, it's definitely something that you might want to think about, at least get a look at. One of the things that we caution our clients on in cloud adoption generally is how do you migrate away after the initial term? Because a lot of these publishers are offering a lot of incentives to get people onto their cloud, but the challenge becomes how do you get off? And if you can't get off, what leverage do you have from a pricing perspective? This is a little bit of an older diagram, but it shows how the licensing model for Microsoft is constructed and where the documents hang in that mix. So what you see is there's usually a master level agreement, which tends to be an evergreen type agreement. And then you have the program level, which is sort of defines what products you're going to be offering, purchasing, what discount levels you'll get, how prices will be calculated. And then you get down into the ordering level documents. This would be the enrollments for particular services and other order level documents that basically specify exactly what it is that you're going to be buying, exactly what program you're going to be in from a ordering level. And so if you think about these levels and then you overlay from a legal perspective the order of precedence, then you can start to understand if you see something that appears to contradict, if there's a contradictory term or an apparently contradictory term at a particular level, you overlay the order of precedence language that's in the master to determine which level will control. This becomes particularly cumbersome when you're also laying over a custom amendment. So the custom amendment could operate to amend any one of these levels. And so we're often looking at, well, if the custom amendment is conflicted by something in the ordering document, how does that get sorted out from a legal perspective involving order of precedence? So something to think about when you're looking at the document stack that you receive from Microsoft and then thinking about where your custom amendments fit into that stack, and when you're doing a final review to be cognizant of the order of precedent as to how any conflicting terms might be interpreted on that basis. Online subscription agreements are probably the area of the most growth for those of you who have been doing Microsoft licensing over a long period of time. This would be the area that would be relatively new. If you've done enterprise agreements in the past where you've primarily been looking at on-premises deployments, then the online subscription agreements might not be something that you've had a lot of experience with. I would tell you that in the modern, the current negotiations involving enterprise agreements, as you can imagine, given the emphasis on cloud and the fact that all of the cloud-related terms and conditions, or many of them, are being outlined in these agreements, that the online services terms, the acceptable use policy, and the security commitments, as well as the custom amendments related to these agreements, are where we're spending a great deal of time in terms of review and negotiation. The enterprise enrollments, these are not new in the sense that, the on-prem enterprise agreements always had the enterprise enrollments. The perpetual license enterprise products, that was the old per device or hybrid per device or per user. And then your suites and your cows kind of go along with it. With the enterprise cloud suite, we moved to licensing more of what was traditionally device-based on a user basis. and looking at things like Office 365 and designating, what levels of 365, and looking at things like mobility and SA on a per user basis. And then we have what would be an optional enrollment. It's not in every deal, but the server and cloud enrollment allows you to license server and cloud products across the enterprise. Also referred to, for those of you who are interested in Microsoft acronym bingo, that's what they refer to as the SCE. The MPSA, which was formerly the Select Agreement, is based on a point system, and many of my large enterprise clients have an enterprise agreement where they buy their main sort of core enterprise products, and they may buy some additional products under that enterprise agreement, but then they've got a Select agreement that runs, or an MPSA agreement that runs in tandem with that for one-off purchases or other products that they don't necessarily want to buy under their enterprise agreement. So it's not the case that you either buy under an MPSA or an EA. For most clients, they're buying some products under both. And for clients of a certain threshold, the MPSA is the option of choice. When you get to 1,500 to 2,000 devices and you don't have an enterprise agreement, that's when I start counseling my clients to evaluate adding the enterprise agreement to an MPSA, particularly if they're interested in pricing, particularly if they need custom amendments or other flexibility from Microsoft. What we find is that the MPSA, from a practical perspective, Microsoft offers very little flexibility in negotiating the terms of the MPSA, and if you really want to have custom terms with Microsoft, favorable or highly customized terms, the MPSA arrangement is just not a vehicle to accomplish that in my experience. That being said, the MPSA has a role for those customers that are not large enough for enterprise agreements, and also has a role to play for the customers that do have EA agreements. One of the things that I don't like about the MPSA is that the audit provisions in the MPSA are a little bit more onerous than what we saw in the Select. And generally, for banks and other regulated institutions, the MPSA doesn't offer the flexibility in terms of custom terms that are, in my opinion, required to be in compliance with certain regulations like HIPAA or GLBA. One of the things that I've learned in now 13 years negotiating enterprise agreements is that the biggest mistake that customers make with Microsoft is failing to get clear with them up front what their needs are. They let Microsoft drive the discussion. They wait for Microsoft to give a proposal, then they say, no, we don't like the proposal, give me another one. What I like to do with my clients is, before a renewal period is coming up, or if a new deal is being negotiated, well in advance, and I'm talking 180 to 90 days in advance, let's come together, build the internal stakeholders from the various departments, infrastructure, IT, finance, legal, compliance, get everybody together, and let's work up a requirements document. Our form template comes out as a PowerPoint presentation. It's a slide deck. It offers the ability to be used as talking points during kickoff calls to go through what is needed. And it goes into a great deal of detail on providing all of the information that Microsoft will need to give you a proposal that could be a full proposal that a deal could be based on. Instead, what I see people doing is not getting clear in their requirements, and it causes a great deal of inefficiency, sometimes frustration, and frequently poor outcomes in terms of benchmarking what you accomplished in the negotiations. We generally find that clients that get clear up front and use this approach wind up with better outcomes. Similarly, the Microsoft term sheet, the EA term sheet that we have developed, has become an invaluable approach to working on the negotiation, evolving from the requirements definition to a detailed discussion on a point-by-point basis, driving that discussion on the issues that matter to the customer instead of waiting and reacting to a stack of documents that is, in my opinion, relatively one-sided in Microsoft's favor. And so we recommend that our clients deal very directly and at the term sheet level before commercial terms have been finalized on key terms like audit clauses, limitations of liability, who pays if data goes missing, etc. All of that is included in the term sheet. And what the term sheet does is it guides the parties' negotiation. And what we're trying to do is to help to identify where the client needs to focus on the language that needs to be changed. Many times these changes take the form of a custom amendment. And so what we're really saying is these are the legal issues on a terms and conditions basis that are important to us. This is what our ask is. Microsoft then can respond within the term sheet as to what their answer is. And then the term sheet can go through multiple iterations, can be used to guide both the business and legal discussions before drafting starts. So much time most important. And so I think that is a very valuable thing to use and something that I recommend that all of my clients use in deals. And we, for the first time today, are making a version of Scott & Scott's Enterprise term sheet available to attendees of this presentation. And if you are interested in receiving a copy of it, you can contact me or anyone on my team, and we'll be happy to send you a guide and the issues that are connected with that. I would say, by and large, a large percentage of the deals that I've been working on over the last couple of years have been heavily focused on Office 365. How do you migrate from a primarily on-prem approach to Office Suite to a cloud-based approach? What does it look like to transition, and what new issues are being created, and how do we account for the already invested dollars for the deployments that we've made? We've seen a number of creative approaches to recapture some of that lost investment. It could be through the use of transition SKUs that carry a lower price for a period of time, or the ability to use the service for a period of time before you have to pay. But the most important factor that we see that complicates this transition. And again, not unique to Microsoft. But once you start transitioning from an on-prem focus to a cloud-based focus, data privacy and protection concerns must drive the decision-making and the negotiation. In every major deal that I work on, the limitation of liability related to what happens if something goes bad. You know, the limitation of liability says these are the circumstances under which the vendor, in this case Microsoft, will not have to pay you for your damages. It is a contractual provision that otherwise takes your legal remedies that would be available to you in court and contractually reduces or eliminates them. One of the things that is amazing to me is that in cloud deals generally, and including Microsoft deals, that the limitation of liability almost universally contains boilerplate that gives the vendor unlimited liability limitation for indirect claims, which include claims for lost profits and business interruption. As I think through the probable claim scenarios for cloud, when I think of business continuity loss, indirects is where all the claims are going to be. So if you're carving out indirects completely, then the limitation of liability negotiation really is about who pays for privacy and security claims. And in the traditional tech procurement world, what we do with our vendors is we require our vendors to bring third-party cyber liability insurance coverage to make us whole in the event that the vendor's negligence causes an injury. And we require the vendor to indemnify us and hold us harmless. Every one of my major corporate clients has a policy from a procurement perspective that these are check-the-box kind of requirements. The problem is that the major vendors either don't carry professional liability insurance or don't commit to do so with their customers. And so they self-insure. And so the risk transfer mechanism that we see in most deals for cloud, which involves a third party that's going to help both parties deal with risk transfer, is eliminated. And so now we're dealing with a self-insured approach, and there's really two major provisions that deal with risk transfer. One is indemnity, and the other one is limitation of liability. And how you negotiate these is extremely important. One of the things that I like to do with limitation of liability is include my client's requirements for limitation of liability in the requirements document, include it in my term sheet, but don't bog the negotiations down with limitation of liability discussions until most or all of the other terms have been negotiated. So if I'm negotiating a deal with Microsoft and the issue of limitation of liability comes up, we'll go back and forth on it, and then I'll say, listen, it's clear to me that we're not going to agree on this now. Why don't we table the limitation of liability issue for later, and let's talk about the other issues that we can make progress on. The reason this works is that both sides, both the customer and the vendor, really struggle to determine what limitation of liability and what level of risk transfer they're willing to take. until all of the other salient details of the deal have been crystallized. Because in the end, this is a business decision about how much risk do we want to take. The revenue opportunity and the margins in the deal and the type of deal structure from the vendor's perspective control their level of interest in what they're willing to do. Similarly for the client may be interested in accepting a little bit more risk in exchange for better pricing or other terms and conditions that are important to them. And so almost every deal that I work on, the last term that gets negotiated for deployments that increase over the base amount. One of the new developments is that there's a language change and a requirement that customers true up to what I refer to as the high watermark, or the maximum usage levels of additional products ordered under the EA. And it's almost impossible, if not extremely difficult, to true up to the high water mark unless you're monitoring your usage on a daily basis. For most of my enterprise clients, we set up a project a couple of months in advance of the true up time calculation for determining what, if any, products need to be added to the true up, and then we place a true up. This high watermark approach is something that I think very few enterprise customers could comply with, and it's also something that we see that Microsoft is pushing a product called Movair, which is by a company, Unified Logic, and one of the features that this Movair product has is the ability to calculate the high water mark. So what we're envisioning is Microsoft requiring the high water mark, knowing that most clients will have very difficult time calculating it, and then through SAM engagements or audits, putting Unified Logic, sticking Unified Logic on the clients to run Movair to challenge the true-up orders that enterprise customers have been making in connection with true-ups. One of the biggest issues that we see as clients accept that they're going to be moving to the cloud is price protection. If I dismantle my on-prem technology infrastructure and move it into your cloud, and I have a certain price for a period of time, I don't want to be in a situation where the price changes significantly at the end of the initial term or during the initial term, such that I'm faced with the rebuilding of internal infrastructure or having to move away to another vendor because I failed to get a price protection language for a renewal term. And I think many clients are failing to appreciate the magnitude of a problem that if you concentrate all of your spend or a large portion of your spend with a particular vendor who at the end of the term owes you nothing in terms of perpetual license rights, and at the end of that term, if you don't renew, they can turn you off, and you've got nothing to protect you on price, you have just given that vendor an incredible amount of leverage. And this may have something to do with why Wall Street is favoring cloud revenue over on-prem revenue, because it's stickier and gives the vendors greater leverage in future price negotiation. The other thing that we've spent a lot of time on, and again, during the recession that occurred from 9 to 11, we saw a lot of our clients in large enterprise deals restructuring, downsizing, laying off workforce, divesting of business units. And we have always recommended to our clients when negotiating long-term deals, you've got to have some provisions in those deals that protect you if things go wrong. In a typical Microsoft deal, there are initial order minimums that are based in large measure on your current business. If you have a dramatic business downturn, we recommend that you have provisions to mitigate the risk of having to purchase products or services for users or devices that may be removed during the EA term. It's a basic kind of thing to ask for, and it just says if things don't go as expected, we don't want to be in a situation where we've got a significant business downturn, but our spend is based on a much bigger operation than what we'll have at the end of the term. So we need the ability under certain circumstances to create some downturn. Now, subscription-based models have some of this built into it. You know, in the old EA model, you didn't have the rights to float down your subscriptions, or if you did, they were limited. But with the current approach, the subscriptions have some ability to go up and down. The issue is if a business downturn would take you below the need of your initial order minimums. Restacking is something that I began using about 10 years ago in the on-prem world because my clients were not sure exactly what products they needed, but they were out of time in terms of doing a deal. So they would agree to sign up on a deal with Microsoft, provided that Microsoft would give them some flexibility within the first year of the term to replace unneeded quantities with different quantities of another product that the company needed. The idea was, I don't want to buy all this stuff and then 6 months into it learn that I've got to buy a whole bunch of other stuff when I've got the things that I bought that it turns out I don't need or don't need as many. And so restacking is a tool that can be used in a number of different contexts. It gives the customer the flexibility to commit to a spend level, but gives that customer the ability to restack or rebundle its mix of products and services with Microsoft to optimize its spend as information becomes available to it. We use this today where we have clients that are involved in significant M&A activity, or where we have an information disconnect about exactly what products and quantities we need, but we still have a need to finalize a deal before all that information can be evaluated. And so restacking continues to be a great tool for enterprise negotiations, even in a cloud-based world. Another one of the big ones that we spend a lot of time on are audit rights. What rights does Microsoft have to audit? For my large enterprise clients, they're spending a tremendous amount of time and resources responding to, staffing, and defending software audits, not only from Microsoft, but from other vendors. And frankly, we as a group are getting tired of it. And we as a group are starting to push back and say, no, we don't want to be audited for no reason. We don't want your auditors to come in and disrupt our business. We don't want to run third-party tools in our environment when you and your auditors will not take responsibility for crashing our systems if that happens. And so audit rights and audit forbearance, which is a concept that I've been using for many years, which is an agreement from the vendor to decline from exercising their audit rights for a period of time. My time frame that I like the most is 3 years during the term of the agreement. Sometimes very difficult to get, but a good place to start. My attitude on audits is, having defended over 500 of them, is that the best audit is no audit. The best way to get no audit is by precluding the vendor from auditing in the agreement, or significantly limiting the circumstances under which they can audit. And audit rights continue to be, even in a world that is increasingly cloud-oriented, a significant contractual term that's being reviewed. Regulatory compliance is in that primary category of data privacy and security. And I will tell you that the base documents that come from Microsoft for an EA deal do not, in my opinion, cover the requirements for an institution that is governed under GLBA, so that's financial institutions, banks, and other companies that are regularly engaged in providing financial goods and services. There are definitely custom amendments that I recommend for my banking clients when they're doing EA agreements, as well as for my healthcare clients involving HIPAA. This is a major concern for large corporations and regulated entities as they begin to evaluate migrating from on-prem deployments where these considerations are not as important. Why? Because GLBA only applies if the vendor is a service provider, and only a service provider if they have permitted access to client financial information. Once you go into the cloud, then you've got permitted access, and now you've opened up a whole world of regulations that were not contemplated by a typical on-prem enterprise agreement. The other thing that is on the horizon, those of you who follow international law are no doubt aware of GDPR. This is a regulatory scheme that's slated to go into effect in 2018 in Europe that has some very interesting provisions in it, including the right to be anonymous, which would require a vendor to be in a position to eliminate any trace of a particular customer who opts to be anonymous. So there's a lot of challenges coming down the pipe, existing challenges under U.S. law as well as federal law. We're seeing a lot of things with Russia. We're seeing a lot of things with Europe, and regulatory compliance, privacy and security concerns really are driving the boat. The way I look at the regulatory compliance issue is one of, can we do this deal the way it's written from a compliance perspective? And if not, we need to communicate to the vendor what we need to have them change or include. And then once the regulatory hurdles are overcome, that's a black or white, then it's, should we do the deal? Do we have the terms and conditions included that are appropriate? Many of my global clients have long pages of entities, hundreds and hundreds of entities all over the world, some of which don't meet the standard definition that we see in the industry for what is an affiliate. And if they don't meet the definition of an affiliate, then the license grant doesn't extend to them. And so if you're operating with businesses that you're controlling that are gaining access to your IT infrastructure where you don't own at least a 50% interest, then you may have a problem with your licenses with Microsoft or any other vendor. For example, I have clients that operate with joint ventures in countries where they're prohibited from owning a majority interest of a company in that market. Operationally, they treat that company the same as the way they treat all their other businesses, but it doesn't technically meet the definition of an affiliate. And therefore, if you have international operations, if you work with joint ventures, if you have unconventional access to your IT infrastructure, then this affiliate definition and your affiliate enrollments as part of your enterprise agreement require careful attention. Similarly, the way that you treat acquisitions and divestitures is a very important aspect of negotiating with Microsoft. I would suggest to you that for large enterprise clients engaged in a lot of M&A activity, either acquisitions or divestitures, the base approach that Microsoft lays out does not afford the type of flexibility and other details that are necessary to protect the client from having to buy twice, from overpaying, from being in a compliance bind, right? And so one of the things, for example, is transition services. If you sell a company, that company is no longer an affiliate on the day that you close. So as of the closing, you would be required to have them have all of their own licenses and not be able to access your system. Well, as a practical matter, for large companies that we represent, that's not possible. Most of the M&A deals that we work on involve transition services agreements for a period of time, and a big portion of those transition services relate to IT. And so having the ability to cover that situation where your license grant extends to the ability to provide access to a divested entity becomes critically important to being able to operate the business during the term of the agreement. Those are the prepared remarks. I purposely reserved some time for questions. If you haven't presented your questions yet, please take a minute to use the box on the right to ask your questions. If for some reason we don't get to your question, and frequently we're not able to get to all of them, we will take some time afterward to respond to questions via email. So the first question is, can we please get the deck when you are done? The answer to the question is absolutely. We will provide a copy of the deck in the email follow-up that you'll receive. So if you registered for the event, we will send the slide presentation to you at the same email address that you used for your registration. Okay, guys, we've just been scrolling through these questions, and the next question is, at what annual dollar level do you find licensors like Microsoft will be willing to, 1, engage in a negotiation, and 2, increase the limitation of liability? Do you find in those instances to be tied to a multiple of fees? If so, what multiple have you been able to negotiate? So I would say any time that you're at the enterprise level we have found that Microsoft will be willing to negotiate on any of the terms that are contained in the enterprise agreement. I definitely think that their interest level and willingness to negotiate is commensurate with the amount of spend. We definitely noticed that our largest clients, in some instances, are able to get significantly better terms based on their bargaining power than what someone of lower bargaining power would be able to get. But we don't see any significant difference in Microsoft's willingness to discuss the issues. And so I would say that anytime you're at a level of enterprise, you can have some discussion. If you're MPSA, you're going to get nowhere. Generally, we do find that limitations of liability are connected with some multiple of fees. As far as what we've seen them negotiate, we're not at liberty to disclose that, but we generally would recommend that the clients start with a multiple of fees that is at least equal to the total dollars that would be paid or payable under the agreement. So if a client is paying $1 million a year, then we would say that at a minimum, we would recommend the clients ask for $3 million or 3 times the annual fees, to give you an example. But that's how some of the negotiations start. Obviously, the actual terms that any of my clients would have achieved would be confidential to my clients, and therefore I would not be at liberty to disclose it. But I would recommend to a client to be looking for not less than the total amount paid or payable under the agreement. Someone has asked for my email address so that they can request the term sheet builder. If you're interested in the term sheet builder, you can get it by emailing R.J. Scott at Scott & Scott LLP. Again, if you'd like to get a copy of the enterprise agreement term sheet builder, my email address is rjscott at Scott & Scott LLP. Next question. How often have your clients been able to add limitation of liability, downturn, or restacking language into their agreements? I would answer the question by saying very often. If you're in an enterprise negotiation, these are terms that come up very regularly. Can you provide some examples of leverage that you have used to negotiate these terms? Sure. My client is a large corporation. They're coming to the end of an enterprise agreement that involves, primarily perpetual licenses. They're considering rolling out Microsoft 365 for their office suites and considering migrating a large portion of their data operations to Microsoft Azure. Total spend, $12 million a year, 3-year commitment, $36 million. And we tell them this is what we want in return. And in that situation, they have 36 million reasons to give us what we want. What shortcomings does the Microsoft agreement have with regards to HIPAA or other regulations? Well, I think the biggest issue, the clearest way to answer this question is with regard to GLBA. The standard Microsoft agreements, when it comes to the section on compliance with laws, and this is not unique to Microsoft. IBM does it, Oracle does it. The basic approach for publishers is to say, we'll be compliant with the laws that affect us, and then you'll be compliant with the laws that affect you. The problem with such an approach is that regulations like HIPAA and GLBA are designed to bind the vendor to the same regulations that the customer has. So compliance with laws provisions that say, you comply with yours, I'll comply with mine, are structurally incompatible with those regulations. The whole purpose is that the vendor has to agree to implement appropriate safeguards, has to agree to do the things that, for example, the bank has to do. Otherwise, you could erode the value of the regulations through outsourcing, which is the whole purpose of the regulation. So they're just not built in its base stack generally does not include a BAA. So if your base stack doesn't include a BAA and Microsoft is going to have access to your client's health information, then you must get a BAA. So it's not so much that it can't be done, because it certainly can be done. It's just that you've got to fight to get these regulatory compliance provisions included. They're not going to just come out with it out of the gate for everything you need. What do you recommend be involved in the negotiations on the Microsoft side? What level of account exec, legal, or other? This is a question that in large part is dependent on the size of the client, the market they operate in, what the account team is in that market, how valuable Microsoft perceives the relationship. As a general proposition, most deals that we work on will include a licensed specialist that has the ability to negotiate, and then someone from the LCA group, the Legal and Compliance and Affairs group, that will help us with the final negotiations on the terms and conditions. Next question, do you assist with large enterprise license negotiations? And if so, can you send me info on your services? Absolutely, we do assist with large enterprise license negotiations. It's a very large part of my personal practice, and many of the lawyers here who work at Scott & Scott focus on that. If you want to send me your email, I'd be happy to send you some additional information. As well, you can review our website at Scott & Scott LLP, which will include information on our services. There are a number of other questions. All of them look to be very detailed and worthy of further discussion. Those of you who have asked questions who haven't received their response, you have my commitment to answer these questions and get answers to you via email. You'll be hearing from me or my team. In some instances, if I feel like it would be easier to answer your question by phone, I may have my assistant reach out to you to schedule some time on a complimentary basis to answer your questions. I want to thank everybody very much for attending today and look forward to speaking with you again in the near future.